Chair Smith, we're live.
Okay, excellent. So we're ready to go. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 17th, 2021. We have 9 bills on the docket. I'll just read off the order and then we'll start off with Delegate Shetty. So we'll start off with House Bill 9. We'll go to House Bill 19, 243, 297, 322, 352, 367, 399, 451. We'll end up with Delegate Henson. So without further ado, we'll start off with Delegate Shetty with House Bill 9. Delegate Shetty, the floor is yours.
Thank you so much, Chair Smith, Vice Chair Wellstreicher, and esteemed members of the Judicial Proceedings Committee. Thank you so much for the opportunity to testify today in support of HB 9, which will require the Department of Human Services to make available online a free course on child abuse prevention, identification, and reporting. This bill passed the House Judiciary Committee unanimously, and it passed out of the House on a consent calendar vote of 131 to 4. As many on this committee are aware, mandatory reporters of child abuse include healthcare practitioners, police officers, educators, and human service workers who are acting in a professional capacity and who have reason to believe that a child has been subjected to abuse or neglect. Although they must notify a law enforcement agency or a local department of social services if they suspect abuse or neglect, only certain mandatory reporters are actually required by law to take trainings on how to identify, prevent, and report suspected abuse. In fact, there are entire groups of mandatory reporters who have a requirement to report, but may not be provided the training they need to appropriately know how to identify and report instances of abuse. As many of you might know, I have a 5-year-old son. He is one of the most important people in my world. And I'm so grateful that here in Maryland, we require our public school teachers to complete trainings like the ones referenced in this bill. But what about the amazing preschool teachers that are mandatory reporters? Although his school recently instituted a required training for their instructors, it's actually not mandated by law. What about his karate or his swim instructor? They're not covered by any law and could certainly benefit from this type of training. One of the saddest outcomes of the COVID pandemic has been a significant uptick in domestic violence and abuse across our country. Providing an easily accessible, online, free training will help any one of us be able to be the eyes and ears that help keep Maryland's children safe. In speaking with some of my good colleagues in the House who are also parents, I learned that many of them have looked into these types of courses for adults who work with children in their own communities. And I'm sure some of you on this committee have done so as well. Last session, one of my Judiciary Committee colleagues indicated that they were actually looking into having these courses for their Sunday school teachers, but it was prohibitively expensive at about $150 per teacher. So by providing a free, easily accessible certification course on DHS's website, like the District of Columbia currently does on their Department of Social Services site, we can ensure that all youth-serving individuals like ballet and karate instructors, Sunday school teachers, preschool teachers, and others have the tools to identify the signs of abuse and know how to prevent and report it to the appropriate entity. This bill is identical to a bill, HB 460, that passed the House of Delegates unanimously last year, but it was unable to be considered by this committee before our early adjournment. I'm very grateful to DHS for their continued support of this effort and to advocates who continue to support its passage. I respectfully request a favorable report of HB 9. Thank you.
Excellent. Thank you very much, Delegate Shetty. And since this is sponsor only, that'll conclude the hearing for House Bill 9. Always good to see you, and we will be in touch soon. All right, next we'll go to Delegate Holmes with House Bill 19. Delegate Holmes, you are up.
Good afternoon, Mr. Chair and members of the committee, and I want to give a special hello to your brand new senator over there from Prince George's County. It's good to see all of you here. This bill is simply a clarifying bill. HB 19 simply clarifies requirements related to written agreements when entering into a process of real estate sale with an escrow agent. If you recall, back in 2019, we had a bill talking about what happens with deposit money, et cetera. And that bill in 2019 didn't quite get as far as we wanted it to. And I'm going to talk now very, very briefly about some documentation that you probably have in your testimony from the Maryland State Bar Association, which clearly lays out why this bill is necessary. As is stated in the testimony that you have from the Maryland State Bar Association, it says, and I quote, this bill simply seeks to carry out what was intended when Maryland Code of Real Property Article 10-802 was enacted in 2019. As I indicated earlier, we thought we had taken care of it, but as continued in the statement by the State Bar Association, when the settlement companies tried to comply with the new law, and as I indicated, the new law in 2019, they were stymied in their efforts because the statute was drafted too broadly and captured sums that were deposited by buyers for which the seller had no claim if the transaction did not close. And we're talking about the down payment monies in this particular transaction of sale. So, Mr. Chair, members of the committee, this bill, HB 19, is simply to clarify what we thought we took care of back in 2019, and ask for your favorable recommendation, Mr. Chair.
So thank you, Delegate Holmes. We have one member of opposition, so we'll turn over to Mr. Margell.
That's for 367.
Oh, that's for 367. That's right. Sorry. There you go. My apologies.
That's major.
While you're here, we'll go on to, we'll keep plowing through your bills, and we'll go through House Bill 352.
Thank you, Mr. Chair. House Bill 352 is a bill that is referring to annual meetings. And the bill, in terms of condominiums, adds an additional member to the Board of Condominiums when the sale triggers at 25%, and 25% of the sales of the properties from the declarant to the public. And what we're doing here, Mr. Chair, members of the committee, we are attempting to add a member of the public to the board of directors early in the process, so that when the declarant is no longer involved, there is an education process, historical content education that is continued when the declarant leaves. This bill came out of the floor in 2020, 131 to 0, and then went over to the House and got caught up in the early adjournment last year. So, Mr. Chair, unless there are questions, hopefully move favorable, or hopefully have you move favorable on HB 352, Mr. Chair.
Excellent. Thank you very much. So that concludes the hearing for House Bill 352. We'll now move on to House Bill 367.
Thank you, Mr. Chair, members of the committee. House Bill 367 is a bill that all of you are very familiar with. This bill, or some form of it, I had put forward, and probably a couple of others had put forward, 2013, 14, 15, 16, 17. I skipped 19, I did 20, and here I am again in 2021. What this bill does, Mr. Chair, is this bill establishes a licensing process for regulating common ownership community managers. And the way I have crafted this bill, Mr. Chair, is that, the way I have crafted this bill, Mr. Chair, is that it mirrors the same type of licensing process and procedures that take place now for the Real Estate Commission, as an example. I have put into this bill a process that was recommended by the Task Force for Common Ownership Communities in their report in 2006. And since 2006, there have been efforts to try to get common ownership community managers licensed. And if you look at some of the testimony, particularly with the Attorney General's office, you will see that there have been many cases where some common ownership community managers have been less than honest with the persons that they are managing, and the Attorney General has had to go to court to find where this missing money was. And the licensing process that I'm putting together here is a step forward to help prevent some of these injustice to our common ownership communities. And with that, Mr. Chair, I will open it up for questions, because as I indicated before, you've heard this bill at least 5 or 6 times, and I will open it to the chair for questions.
Thank you, Delegate Holmes. We'll now move on to your you have one witness signed up for the unfavorable. Mr. Margell will ask for you to provide testimony, then we'll move on.
Chris Majorly, how are you, sir?
I'm fine. And you, top of the morning or top of the day to you now, Mr. Chair and Delegate Holmes and members of the committee. I am Chris Majorly. I'm a Community Association Manager, and today I'm here representing the Community Association Institute's Maryland Legislative Action Committee, or the Maryland LAC, where we promote the interests not only of our manager practitioners, but our thousands of owners who are members of common ownership communities. I've worked with Delegate Holmes for some 6 years on manager licensing through this committee, and unfortunately, we find ourselves now opposing manager licensing. One might ask why an association, which is the only one to offer the required designations, which would find all of our area managers being required by law to be dues-paying members, to purchase our training, and to pay ongoing designation and maintenance fees, why we would oppose such legislation. And the answer is twofold. We've come to realize that manager licensing does not achieve the desired results, and it's just too expensive. We who are members of CII and hold these designations have invested in ourselves to differentiate us from those who hold up their hands and call themselves community managers. Embezzlement is a crime punishable by imprisonment, and if prison doesn't deter the crime, what deterrent would a license suspension or revocation be? You cannot legislate honesty or a commitment to excellence. Colorado found this to be the case and allowed their law to sunset, leaving only 8 states with manager licensing, and one of those, Virginia, is considering dropping their manager licensing. The fiscal note pegs the initial cost of the state board at only $100,000. In prior years, the projected cost resulted in an estimated license fee that was 4 times that of any other state license. In speaking to homeowners, I find manager licensing is very popular until they learn at what cost it'll come to each of them. Ultimately, all business costs are marked up to cover direct cost, administrative cost, time expended, and a profit margin. Additionally, the bill requires management companies to obtain a fidelity bond to protect against embezzlement. But association funds are already required by law to be protected by the association's fidelity bond. This bonding requirement is duplicative and will be passed through to the owners. To help defray license costs, the bill requires registration of communities with a per door fee. This direct cost to our homeowners would be in addition to the aforementioned pass-throughs. No one has yet determined the true cost that will ultimately rest on the shoulders of our homeowners. All of this comes at a time when Prince George's County is facing the impact of the new reserve study law, which may go statewide in 2021. And in my view, homeowners are much better served by investing in the infrastructure of their community.
Time.
We just urge the members to read the other opposition letters that have been sent, and there have been some 1,350 responses to our call to action. It's an expense that people simply don't want to pay. Thank you.
Excellent, thank you. And with that, that'll conclude the hearing for Senate Bill 367. We'll now move on to Vice Chair Atterbury. We'll go back down the list with House Bill 243. Madam Vice Chair, always good to see you.
Hi, good to see you, Mr. Chair, Mr. Vice Chair, and members of the committee. I miss my colleagues, but good to see you virtually. So this is how I'm here to ask for a favorable report on House Bill 243. This is, I think, my 3rd time putting it in, and I think actually well before I was elected, the former chair of JPR had this bill, I believe. And so essentially it creates a new ground for divorce for individuals who are living in the same household, but who cannot afford to create expenses for a second household. If they can show that they have been living separate and apart in the same house for a period of 6 months, then they can file under the new irreconcilable differences. It also creates a limited divorce on the ground of irreconcilable differences. And there was some concern in the committee from some of my colleagues that you could be, quote unquote, I guess, divorced by surprise. So if you do file for divorce or file for a limited divorce, then there is a 6-month waiting period where you have to give notice if you want to file for an absolute divorce. And with that, I would just ask for a favorable report.
Excellent. Thank you, Madam Vice Chair. And with that, that'll conclude the hearing for House Bill 243. Good to see you.
Thank you.
We see a lot more of each other in a couple days.
I know.
Good luck. All right. We'll now go to Vice Chair, Madam Vice Chair, Delegate Peña-Melnick.
Thank you. Thank you. Good afternoon, Chairman Smith and Vice Chairman Stryker, members of the committee. It is a pleasure to present to you today House Bill 297. In 2019, our legislature voted unanimously to create the Maryland Lynching Truth and Reconciliation Commission. In doing so, Maryland became the first state in the nation to launch this effort to heal the horrific wounds of racial injustice. Since then, the commission has been holding meetings throughout the state. On November 2nd, 2020, the commission was awarded $300,000 in federal funding to complete their work. House Bill 297 simply revises the date for submitting the final report and extends the commission's cessation date so they can complete their work. I respectfully request a favorable report. Thank you so much.
Excellent. Thank you, Madam Vice Chair. And with that, that'll conclude the hearing for House Bill 297. Good to see you.
Nice to see you all.
Next, we'll go to House Bill 322 with Delegate Hill.
Thank you very much, Mr. Chair, and good afternoon, Mr. Chairman and Mr. Vice Chair and committee members. For the record, I'm Terry Hill. I'm presenting on House Bill 322, restrictions on use of low impact landscaping. And to be hopefully as brief as my other colleagues were earlier today, this is a bill that simply protects homeowners from overly restrictive homeowner association limitations on how they can do their landscaping. It gives them the protection to do landscape that would be, I'm sorry, I had to move something there. Landscaping that is consistent with sustainable communities, whether that's pollinator landscapes or water retention and things of that sort, but it also allows the homeowner associations to do their primary responsibility, which is to make sure that the home values in the community are not compromised by landscaping that would be detrimental to the community as a whole. So this is really designed to strike the exact balance between the homeowner's rights as an individual, trying to do the sustainable thing and do right by our government, and the homeowners association's responsibility. And just to be clear, when we talk about sustainable or low impact landscaping, we're talking about sustainable gardens that control storm runoff, biohabitat and pollinator gardens. We're talking about rain gardens and xeriscaping, which reduce and eliminate the need for supplemental water for irrigation and planting of more trees. So in the name of a better environment and a brighter future, we ask for your favorable support. The bill passed out of the House last year, and unfortunately, because of the pandemic and our early adjournment, did not get out of this committee, and it passed unanimously from the HGO committee this year, and the floor 126-4. Thank you.
Excellent. Thank you, Delegate Hill. Always good to see you, and stay safe. So with that, that'll conclude the hearing for House Bill 322. We'll now move on to Delegate Krim with House Bill 399. All right, if Delegate Krim is not ready, we'll move on to Delegate Henson with House Bill 451.
Hello, this is Delegate Krim.
Hey, Delegate Krim. All right, you're up with House Bill 399.
I was voting in my subcommittee.
Oh, no worries.
Just fine. And how are you, Mr. Chairman? It is so good to see you.
Likewise.
And members of your committee, I've just missed you all. So let me get on with this. HB 399 was passed in the House last year, but we adjourned before the bill was considered by this committee. Let me tell you a little bit about the bill. The Maryland Department of the Environment has identified 4 counties in Maryland, Baltimore, Frederick, Carroll, and Washington counties, as having zones of dewatering influence as a result of surface mining or quarry operations because of karst terrain in these counties. There is a possibility that sinkholes may develop in these zones. HB 399 provides for real estate sales contracts in these 4 counties to include a notice to alert the purchaser to check with the Maryland Department of the Environment to determine if the property is in one of these zones. The benefit to the purchaser is that they can now purchase insurance to cover their property in the event a sinkhole develops. This actually happened in the city of Frederick. One house where the sinkhole appeared had insurance and the house next door did not. It can mean financial hardship for people who do not have insurance to cover this loss. We consulted with all stakeholders in the House and addressed all concerns. This bill passed 23-0 in committee and 133-2 in the full House. Senator Huff, are you trying to talk to me because you're muted? Okay. I thought maybe you were, because both from Frederick County. So it's a pretty simple bill. It's been vetted, and it just provides notice. So I would appreciate a favorable report, and if you have any questions, here to answer them.
Excellent. Thank you, Delegate Krim. And with that, that'll end the hearing for House Bill 399. Always good to see you. And
thank you. Thank you, Mr. Chairman. Good to see everybody on you and your committee. Thank you.
Thanks a lot. Have a good one. All right, next we'll move on to Delegate Henson. Good to see you. You're up
Thank
next.
you.
House Bill 451. Floor is yours.
Thank you, Mr. Chairman, Chair Smith, Vice Chair Wallstricker, for the opportunity to present House Bill 451. Remote visual inspections is an invention of efficiency and safety. Hundreds of thousands of renters throughout Maryland rely on regular code enforcement inspections to ensure the quality of their rental housing. One of the many lessons we learned in the COVID-19 pandemic is that in-person, in-home inspections may not always be safe or practical during a protracted state of emergency. However, the need for those inspections and what they provide for those renters and also the property owners, that does not abate just because it's not safe or practical to enter someone's unit. RVI, or remote visual inspections, gives us the opportunity to continue to keep up the safety standards that we have in our code. The supporters for this bill include the Office of the Attorney General Consumer Protection Division, Maryland Multi-Housing Association, commercial companies that perform this service, and the town of Shaker Heights, which is located in Ohio. Shaker Heights in Ohio is one of the many states and provinces that has incorporated this type of legislation and enabling legislation. It also includes Florida, Arizona, and many provinces throughout Canada. The way that it works is that the tenant would be in their home. They would use a device such as your cell phone or any other device that you have. They would download the app from their city's website, and they would walk through their home and they would show the code enforcement officer the different items that have been selected and identified for visual inspection. The code enforcement officer would then be able to telework like many other professionals are able to do, and they would conduct the inspection in a remote fashion, looking for those items that are subject to the code enforcement inspection. Thank you for the opportunity to present House Bill 451.
So thank you, Delegate Henson. And with that, that'll conclude the hearing for House Bill 451. Thank you very much. All right, and with that, that concludes our hearings for the day. We'll have a voting session. Let us do this. So we have to be in the room. We can only be in the room for 2 hours, a little bit north of that. So let's take a break here so we can complete some work, and let's come down to the hearing room at, let's do 4:30. Or let's do 4:45 actually. Let's do 4:45, and then we'll vote from then on. 4:45. Sound good to everyone? All right. Let's see everyone at 4:45.